Hi, everyone, and thank you for joining us today for another virtual legal clinic, Know Your Rights Housing COVID-19 edition. I'm Jelena Smallwood, Director of Parent and Family Programs at CS Buffalo, and excited to introduce my colleague, Emily Alvarez, who is the CS Buffalo Legal Clinic Coordinator for the Volunteer Lawyers Project, who will be introducing our amazing panel of attorneys today to share with you some valuable information regarding housing during COVID-19. Emily, take it away.
Thank you, Jelena. Hello, everyone. Thank you so much for joining us for today's Know Your Rights session. I'll be presenting today's speakers, attorneys Christine, Michael, and Chris. Christine McMenamin is the Housing Senior Staff Attorney at the Volunteer Lawyers Project, where she represents tenants that are facing eviction. Before joining VLP, Ms. McMenamin spent over 8 years representing tenants in all matters surrounding their tenancy, as well as recruited and trained law students and attorney volunteers. She also has represented both injured workers and insurance companies in workers' compensation cases. She previously served as a legislative fellow with the New York State Senate in Albany and as a legal intern for the United States Equal Employment Opportunity Commission in Manhattan. Ms. McMenamin holds a Bachelor of Arts magna cum laude from Syracuse University and a Juris Doctor from University at Buffalo School of Law. She is a current member of the Erie County Bar Association and the New York State Bar Association. Next, we will have Michael. Michael Flessa is a housing staff attorney at the Neighborhood Legal Services, where he represents tenants in various landlord-tenant matters. NLS is where he since started his career as an attorney. Mr. Flessa is a lifelong resident of Buffalo, New York, and is passionate about the needs of the city and his fellow Buffalonians. Mr. Flessa received a Bachelor of Arts with honors from the University of Buffalo and a Juris Doctor from Syracuse University College of Law. And finally, we will have Chris. Christopher Siegel is a housing staff attorney at the Volunteer Lawyers Project. His practice is focused on civil legal services, including landlord-tenant law and mortgage foreclosure. Chris was born and raised in Buffalo and earned his degrees at the University of Delaware and the University at Buffalo School of Law. Thank you again to Christine, Michael, and Chris for today's presentation, and I will pass it on to Christine to start us off.
Thank you, Emily, and thank you for having us today. Thank you all for being here. This is a very important topic, and I'm hoping that you will get a lot out of it today and also share this information with anyone you think will need this information. Next slide, please. Okay, so today I'm going to talk about the COVID update as it relates to housing, particularly renting, but there are some things I'm going to talk about that also relate to homeowners. I do have to say that the landscape in specifically landlord-tenant law and the moratoriums is changing all the time. So it's changing very rapidly, and there's been multiple updates. However, this information is current as of late last night and also today. If you are looking at this later on or sharing this information, please take a look at the resources we linked in this presentation for the most up-to-date information. Also, Neighborhood Legal Services on their homepage, which is nls.org, has the most up-to-date information regarding these issues. And I do have to just give another disclaimer that this information today is not legal advice. This is just legal information. If you do have questions and want some legal advice, you can contact Volunteer Lawyers Project or Neighborhood Legal Services for us to assist you. Okay, so I'm going to start today with talking about the federal CDC moratorium on evictions. So the Centers for Disease Control and Prevention has issued a temporary federal moratorium, which just means a ban on residential evictions, and it's effective through March 31st. The federal moratorium, importantly, does not waive any rent obligation of tenants. It also does not waive any late fees that the landlord may charge a tenant if they do not pay their rent. The moratorium is simply putting a ban on the eviction proceedings so that a judge cannot grant a warrant of eviction for a tenant during this time if they qualify. So landlords are not allowed to evict any covered person under the CDC moratorium. The covered people under this moratorium is any tenant, lessee, or resident who gives the required written statement, which is called a declaration, to their landlord or the person with a legal right to bring an eviction. More often than not, the person with a legal right to bring an eviction might be the landlord's attorney, or if you deal a lot with a property manager or somebody else who takes rent but isn't the owner of the property, you would want to give this to the owner of the property. Next slide, please. So the declaration is a written statement that the tenant and all household members, as long as they meet these 5 requirements, they will be covered. The tenant, so first of all, the tenant has to try to get all available government assistance for rent. So if they qualify for any sort of assistance to pay the landlord the back rent, they need to apply for that. The income requirements for the CDC federal moratorium are very high. So as long as the tenant, a single tenant, doesn't expect to earn more than $99,000 in a year in 20, or hasn't in 2020, or $198,000 if they file jointly, they will qualify. But also if a tenant and their family did not receive any income and did not report any income to the IRS in 2019, they would qualify. And if a tenant received a stimulus check under the Federal CARES Act, they would also qualify. Next slide. The third requirement is that a tenant and their family cannot pay the full rent because of a substantial loss in income, because their hours at work were cut, or because they lost their job, for instance, or there's an extraordinary out-of-pocket medical expense. So the actual declaration will list all of the requirements, and you would want to read that over and make sure it applies to you. But basically, if you've had any sort of significant loss of income because of COVID, or you've had an extraordinary out-of-pocket expense, such as maybe you or somebody in your family contracted COVID and were hospitalized and now have large medical bills or have large out-of-pocket medical expenses due to that, you would also qualify even if you did not suffer a loss of income. So fourth, the tenant has made best efforts to try and make some payment to the landlord. This is based on what the tenant can afford. So it is important in the CDC moratorium that the tenant has attempted to pay the landlord based on what they can afford. Obviously, if someone does not have any income coming in, they would not be able to afford anything. But if there is some income coming in, the CDC moratorium requires that the tenant is making some effort to pay something to the landlord. And if the tenant and their family are evicted, there would be a likelihood that they would have to live with family or friends or be homeless. So as long as the tenant doesn't have somewhere else to go, such as they would be able to rent another apartment right away, then they would qualify under the CDC moratorium. And it's important to note that the tenant would have to satisfy all 5 requirements. You can find the most up-to-date CDC declaration for this moratorium at the NLS homepage. It's always changing and there's some extensions. Since the deadline right now is March 31st, all under the moratorium for the federal CDC moratorium, the eviction ban is until March 31st. That may get extended, but for now, you can find all of the up-to-date information at nls.org. Next slide, please. Okay, but the most important information that you need to know is that the state moratorium, the New York State moratorium, protects tenants even more and even further than the federal moratorium. And that's the one we're going to cover most in depth today. So the law that was passed to ban evictions right now in New York State is the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. This was passed December 28th of 2020, and it does also include homeowners for mortgage foreclosure. However, Neighborhood Legal Services and Volunteer Lawyers Project, the majority of our practice is helping tenants, so I'm going to focus on that. But if you are a homeowner facing mortgage foreclosure, please contact us and we can give you more information, more detailed information. So this law ensures New York renters and homeowners impacted by COVID-19 can safely remain in their homes. The act suspends eviction and foreclosure proceedings for 60 days from December 28th to give renters and homeowners the opportunity to submit a hardship declaration. Tenants and homeowners who file the hardship declaration will be protected from eviction and foreclosure until May 1st, 2021. Next slide. This is the only official New York State hardship declaration form, the one that we've linked, and that is at the newyorkcourts.gov website. There are a few other declaration forms on the internet. Please go to the newyorkcourts.gov website to find it, because if you do not use the correct form, you will not be protected. You can also find the form again at nls.org. They always have the updated forms on their homepage. This is what the declaration looks like. This is the one for renters. So it's very simple to fill out. If you already have a pending case, you would put your index number and county and court if you know that, but you can leave it blank if you don't know that or if you do not have a pending case right now. In the first blank, you will be putting your address, and then you will check a box for either A, B, or both to indicate why you qualify under this moratorium. So it is not one or the other. You may qualify for both or one or the other. So A encompasses all of the financial requirements and reasons why you may qualify. So for instance, you may have a significant loss of household income due to the pandemic. You may have increase in necessary out-of-pocket expenses related to performing essential work or related to health impacts due to COVID-19. You may have childcare responsibilities or responsibilities to care for elderly, disabled, or sick family members during the pandemic, and that has negatively affected your ability or the ability of someone in your household to obtain meaningful employment or earn income and increased your necessary out-of-pocket expenses. So what this all means is that if you've had to take care of someone, such as a child or children because they're home from school during the pandemic, or somebody in your household is elderly, disabled, or sick, and because you've had to take care of them, you were not able to work, or your out-of-pocket expenses significantly increased, you would still qualify. If you had moving expenses and difficulty securing alternate housing, and that has made it hard to find a different place to live due to the pandemic, you would qualify. And if there are any other circumstances related to the pandemic that have negatively affected your ability to obtain meaningful employment, earn income, or have significantly reduced your income or increased your expenses, you would qualify. So it's important to note that you don't have to meet all of these requirements. As long as you meet one of them, you could check the box of A and you would qualify under this declaration. So for B, this is more on the health side. So if vacating your apartment and moving into new housing poses a significant health risk because you or somebody in your household have an increased risk for severe illness or death from COVID-19, such as being over the age of 65, having a disability, or having underlying medical conditions, including being immunocompromised, then you would qualify regardless of your financial status. So that would be when you check B. And again, you may qualify under both. If you do, then you would check both of them. You would sign, print, and date your name or date. And it's important to note that this is signed under penalty of perjury. So this is a court document and you are signing that it is 100% truthful, and it's as if you were testifying in front of the judge at court. So it holds the same weight, and the filing this declaration will have your case adjourned until after May 1st, 2021. So what you have to do to file it is give it to your landlord or your landlord's attorney, keep a copy for yourself, and if you have a case in the court, then you would send a copy to the court. If you don't yet have a case in the court, you would just send it to your landlord, keep a copy for yourself, and wait for your hearing date. Next slide. Okay, so we are going to address all questions at the end just for time's sake, and also because we may answer some more questions as we go along. So please hold your questions till the end, but you can leave them in the chat. Thank you. Okay, so again, if you have a pending, before we get into this, if you have a pending court case, it can be an eviction for non-payment or an eviction for a holdover. There is a narrow exception. This isn't in the slide, but there is a narrow exception, and that is only if a tenant is causing harm or is a health or safety risk to others in the building. Then the landlord may be able to bring an eviction case right now. But other than that, they are all stayed until after May 1st if you file the tenant declaration form. Okay, so the next law I'm going to talk about is a New York law. It's called the Tenant Safe Harbor Act. And this was the law that was passed when the pandemic began, in the beginning of everything going on. So this still applies. And there are some differences between this and the last law that I talked about, but this is just extra. So this is just extra information for you. So tenants may raise a financial hardship defense in eviction proceedings, and the court will examine several factors, such as the tenant's income prior to the covered period, which is during the pandemic, the tenant's current income, liquid assets such as cash, and the tenant's eligibility for and receipt of benefits, such as government assistance, various government assistance, unemployment, and other federal and state benefits. Again, right now, if you qualify for that tenant declaration form that I just said, your case would be adjourned until after May 1st. However, if the judge is hearing your case, whether that's now or after May 1st, this could be a consideration. Next slide. Okay, so the Tenant Safe Harbor Act applies to tenants who were served with eviction warrants before the pandemic started. There are some cases, especially in Buffalo City Court, where there was a hearing prior to the pandemic, warrants of eviction were granted. However, everything was placed on hold, and so those cases have not been completed. So this does apply to those tenants. If a tenant has a defense under the Tenant Safe Harbor Act, the landlord might be able to get a money judgment against them, but the tenant cannot be ordered to vacate the unit until the covered period ends. What that means is that the landlord may be able to get the judge to grant them a money judgment for any rent due, but they will still not be able to get an eviction until after the covered period ends. And right now, currently, as of today, we are under a hold of 60 days from December 28th, when the prior law that I spoke about was passed. And if somebody is qualified under the tenant declaration form, then the case would be adjourned until after May 1st. And the covered period started March 7th, 2020, and it ends when all the provisions restricting businesses, accommodations, and non-essential gatherings, as outlined in Governor Cuomo's previous executive orders, come to an end in the county of the tenant's residence. So once all restrictions are lifted in Erie County, then this act would no longer apply. However, that has not happened yet, so this act still is in effect in Erie County. Next slide, please. So now I'm going to turn it over to Michael Flessa, attorney at Neighborhood Legal Services, to talk about some landlord-tenant hot topics. I'm sure people have a lot of questions about what I just said. Please hold them. You can put them in the chat and we'll go over them at the end of the presentation. Thank you.
Hello, everyone. I'm Michael Flessa from Neighborhood Legal Services, housing staff attorney, and I'm going to touch on some of the recent changes that occurred in the summer of 2019 with the Tenant Protection Act and some relevant landlord-tenant hot topics that are going on now. Next slide, please. So one of the most crucial and first steps in landlord-tenant matter that we see frequently is eviction for a non-payment of rent. In order to begin this process, there must first be a 14-day written pay or quit notice. This has been expanded from previously 3 days and a verbal or written demand. And this is what starts the process, and it allows for tenants to pay off the balance of rental arrears before going to court and things of that nature. Additionally, there is now a requirement that a landlord must provide a written receipt of cash payments and maintain these receipts for 3 years. If a tenant is paying their rent in cash, it's absolutely recommended that they do this, have all of their rental payments records kept. This is going to be crucial in the future and down the road if there's any discrepancies in the amount of rent owed or other things of that nature. Additionally, no money judgments can be issued in a default if a tenant fails to appear. This is regardless of the matter of service, whether it be personal or otherwise. However, there still may be judgments of possession or warrant of evictions that could be issued, but a money judgment will not be issued in a default. Next slide, please. Additionally, there are now limits on late fees. A landlord cannot charge a late fee until rent is 5 or more days past due from the date of payment of rent. Generally, this would be the first of the month, but some tenants may pay on the 15th, and it goes by what the lease or the agreement says, 5 days from that. Additionally, there is a cap on these late fees. The late fee is going to be capped at the lesser of 5% of a tenant's monthly rent, or $50. So if a tenant is paying rent of $1,000 a month or over, the maximum late fee that they can be charged is $50. But if you pay less than $1,000 per month, the maximum late fee is going to be capped at a number lower than 50. For example, if the rent you pay monthly is $800, the maximum late fee would be $40, which is 5% of $800. These late fees cannot be part of the eviction petition that we had described on the previous slide. That is limited only to a demand for rent. Rent is defined as the monthly or weekly amount charged in consideration for the use and occupation of a dwelling pursuant to a written or oral rental agreement. Essentially, this is the money that you pay monthly or weekly for the occupation of the unit, and that is what the eviction proceeding demand is limited to. It cannot be for fees and other associated charges like the late fees. Next slide, please. Moving on to service. Service is absolutely crucial in this matter. Summary proceedings are entirely statutory, and the proceeding does not begin until personal service is made. The service of the eviction petition must be between 10 days and 17 days before the hearing date. If personal service is not made, other options such as now and mal or service upon a person of suitable age at the resident can suffice. However, in that case, the proceeding will not start until the affidavit of service is filed. This is important because you may get to the hearing and find out that the affidavit of service has not been filed until that date, in which case service would not be proper. Additionally, when you arrive at trial for a court, if there is an issue of fact that is joined, the tenant or either party is entitled to a minimum of 14-day adjournment from the court date. This is an entitled adjournment that either party can enact if there is an issue of fact. Any other adjournments will be done so at the discretion of the court. Moving on. Warrants. So in the event that a warrant of eviction is issued, the earliest that these warrants can execute is 14 calendar days from the date that it is served, which is an increase from 72 hours in the past. It is common that the execution date will be stayed longer to allow tenants to move. Additionally, in that 14-day window, if a tenant can pay the rent that is owed, they can deposit that full rental arrear sum to the court, and this should vacate the warrant of eviction and preserve the tenancy going forward. Additionally, it is possible for a tenant to request an extreme hardship declaration. This will stay the issuance of the warrant for up to 1 year, and in doing so, the court will consider a variety of factors such as serious illness, the exacerbation of an ongoing condition, continued enrollment of children in a school district, and any other extenuating circumstances. In this case, the tenant will be responsible for depositing the amount of rent directed by the court to the court. This is generally going to be the rate of monthly rent immediately prior to the proceeding, with some additions that may apply. Another important aspect of special proceedings is that there is an absolute stay on any summary proceeding in the event of a utility shutoff that is due to the failure of a landlord or their agent. Should there be an issue with utilities being shut off, any special proceeding to dispossess the tenant of possession or recover rent will be stayed until the amount of rent owed for utilities is paid in such time as utilities are restored. It's absolutely crucial, especially in this time of year. Security deposits are particularly relevant and have changed under the Tenant Protection Act. Prior to moving in, but after a tenant has signed a lease, a landlord must allow them to do a walkthrough of the property. During this walkthrough, tenants have the ability to note any issues and memorialize them in writing, essentially making a note and a record of what the unit looked like before moving in. It's important to note anything such as mold, chipped paint, broken windows, things like that, and make a note of it. Otherwise, it could be possible that a landlord would charge for damages to those when the tenant moves out. As of now, security deposits cannot exceed 1 month's rent. A common practice in the past was for security deposits to be 1 month's rent plus last month, things of that nature. At this point, the security deposits cannot exceed 1 month's rent. And as I described with the walkthrough and things that are memorialized in that, a landlord cannot retain security deposit for conditions listed in that inspection. That's the crucial point of that. Next slide. Now that was the beginning of security deposit. When you move in, when you move out, there are additional factors. 1 to 2 weeks before moving out, the landlord must give the tenant written notice that they may request an inspection before moving out. At this inspection, the landlord should note what they intend to deduct and allow the tenant time to address these issues prior to moving out. The landlord must give the tenant 48 hours written notice of the time and date of this inspection, and the tenant is entitled to be there during the inspection. Post moving out, security deposits must be returned within 14 days of the tenant leaving the property, and they should include an accounting and an itemized cost of any damages that the landlord is deducting from the security deposit. Should a landlord fail to provide the tenant the security deposit within 14 days or provide this itemized deduction, the tenant, there is a presumption that this was willful, and a tenant may potentially receive up to double the amount of the security deposit in damages. If a landlord fails to return a security deposit, a client should file an action in small claims court. Another important new addition is the 30, 60, 90-day rule of written notice. This provides that for certain things, a tenant is entitled to written notice and a certain time frame from that written notice. If a landlord is intending to increase rent by 5% or more, they will not be renewing a lease, or they seek to terminate a month-to-month tenancy, landlords must provide written notice with a time period based on the amount of time a tenant has occupied the unit or the term of their lease. If a tenant has occupied a unit for less than 1 year or has a lease term of less than 1 year, say 6 months, they must be given 30 days written notice. If a tenant has occupied a unit for over a year, but less than 2 years, or they have a lease term of 1 to 2 years, they're entitled to 60 days notice. And if a tenant has resided in a unit for more than 2 years, or they have a term of lease of over 2 years, they're entitled to 90 days written notice. These must be in writing, and if a landlord does not give proper notice, the tenant is entitled to the prior terms of the tenancy until the proper notice period has elapsed. So if a tenant, for example, has resided in a unit for 3 years on a month-to-month tenancy, and a landlord is seeking to terminate that tenancy, and they give a 60-day notice, that would be improper as they've resided in the unit for over 2 years, and the tenant would be entitled to additional 30 days so that the notice period would be proper. Now moving on to some frequently asked questions, I'll turn it over to Chris.
Hi, this is Christopher Siegel with the Volunteer Lawyers Project. So I'm just going to go over some questions that we hear a lot. So first of all, what is the difference between a non-payment proceeding or eviction and a holdover eviction? Non-payment is pretty self-explanatory. It involves rent that is owed, and a holdover proceeding is a term that you don't see. I apologize for the background noise. Holdover is a term that most people don't ever see. It's a weird term that doesn't make any sense, but it just means that you have stayed. A tenant has stayed past the date that they are legally allowed to be there. So if you have a lease, it's staying past the last day of the lease. If you have a month-to-month tenancy and your landlord has given you the appropriate 30, 60, or 90-day notice terminating your tenancy, then it's staying after that period of time. Or if you have a lease that can be terminated early for some reason, and your landlord has given you all the proper notifications that are required in the lease, then it would be staying after that time. This is a distinction that would be important for your attorneys to know, but maybe not an individual. Go to the next slide. So a very common question is what to do if you have bad conditions in your home. So in New York State, every single landlord-tenant relationship includes what is called an implied warranty of habitability. It's implied promise by the landlord that the rental property will be safe and habitable. So it's intended to prevent conditions that would affect the life, health, or safety of the tenant or anybody there that were not caused by the tenant. So you can't create a problem and then expect your landlord to fix it. But also, importantly, it can't be waived. You can't just agree, whether verbally or in writing, that it doesn't apply here, or that you're going to rent the apartment as is, even though the entire first floor is filled with rats. We can go to the next slide. So the type of conditions, the situations where this might apply, again, things that affect a tenant's life, health, or safety and have not been caused by the tenant. For example, a roach, rat, or mice infestation. So the idea is the governing question is whether the rental property is uninhabitable, not whether there's something on a certain list or a certain magic word that you've hit that triggers this. It's whether there are so many roaches or rats that it creates a health issue. Bed bugs, because those spread very easily. No heat, faulty plumbing, bad wiring, no hot water, or no water at all. Those are the kind of conditions that affect health and safety and are obviously dangerous and something that New York State intends to prevent tenants from. Next slide. So how can you get your landlord to take repairs? Well, if you are living in subsidized housing subsidized by Section 8, then you would have to talk to Neighborhood Legal Services for legal advice, or the organization that administers your Section 8 program, such as Belmont Housing. If you don't have Section 8, then here are some ideas of how you can proceed. The general idea is you want to give your landlord notice, you want to communicate with your landlord, and you want to have proof that you did that. So you tell your landlord about it, tell them, what the problem is, and ask them to fix it. And then if they haven't done it, you put that in writing. Send them a letter. If you can, send them a letter via certified mail so that you have proof that it was sent and proof that it was received by your landlord. And in the letter, you would list what all the problems are, where they are. The pipe in the bathroom is leaking water all over the floor. You would explain why it's a problem, especially if there are special considerations. The example here is children that are sleeping in a room and there's a problem right above their heads. If there's a way you're using the apartment that means the problems are exceptionally dangerous for you, landlord might not know that, so point it out to them. And then clearly request that the problem be fixed. You can set a date, give them, a reasonable time frame to do it, and hopefully that will encourage them to respond. If it doesn't, and you have to go to court over it, this will help you later on down the road. We can go to the next slide. Another issue that comes up is retaliation for a tenant contacting the authorities, essentially the health inspector. So New York generally protects tenants from retaliation by creating what is called a rebuttable presumption of a retaliatory eviction if an eviction is filed within 1 year of a complaint. So the rebuttable presumption, the presumption allows the court to presume that it's true that this is a retaliatory eviction. It's rebuttable, which means it can be countered or disproven if the landlord has a legitimate reason for the eviction. For example, if you file a complaint, if you call the inspector and they come out and say, yes, there's mold all over this apartment, and then 9 months later, your landlord says that they're evicting you because you didn't pay rent, that could still be a legitimate eviction if you didn't pay rent for that, that 1 month. The idea is the landlord can counter the presumption and prove that there is a legitimate reason, that they're not just getting rid of you because you complained. So a tenant can complain either to the landlord, to the landlord's agent, if it's a company, an LLC, or maybe an out-of-town landlord. You might have a property manager or somebody that you deal with in person. You can complain to that person, or you can complain to an agency like the Department of Health or a health inspector. And if you can establish that it's a retaliatory eviction, that means that the eviction should be dismissed and that you won't be evicted. We can go to the next slide. So some people come to court assuming that the court has to give them 30 days or some other certain amount of time, that they're going to get time to move and that they're going to get that no matter what. And it's important to know that that's not true. So if you're facing eviction, you need to be making plans about what to do. Hopefully you'll be able to work it out and be able to stay. But if not, you need to know when you need a new apartment by, how soon you're going to need to move out. So it's important not to assume that you get 30 days. And it's also important to talk to an attorney to get specific legal advice, because they can tell you if you have a very bad case and it looks like you're not going to get very much time at all, or they can tell you if your landlord did everything incorrectly and they think you'll get much more time. The actual date, and this isn't something that the court gives you really, but it's required by law that once a warrant of eviction is issued and served, when the marshals or sheriffs come to the property and post the notice on the door, after that, they can't execute it for 14 days. So that 14 days is guaranteed, except in certain cases where there's something like an illegal use or an emergency. If somebody is in a rental property and they are, shooting guns at cars that pass by, then obviously they're not going to wait 14 days for them to be out. It's going to happen sooner than that. But in any kind of, more common standard eviction about non-payment or about an expired lease, then the warrant of eviction can't execute until 14 days after it's been served. And our attorneys, Christine, for example, is a very good attorney, and she may be able to do a lot for you when you're in court. And the hearing officer that listens to the cases and decides how much time you're going to get is a very nice guy, but you still can't assume that either one of them is going to get you 30 days. So we can go to the next slide. This slide and the one that follows after it are a list of resources you can check out for more information. There are some from the federal government, the New York State Attorney General's office, which sometimes helps with landlord-tenant issues when they get more serious. There are administrative orders from the New York State Office of Court Administration. There are executive orders from the governor of New York State. But the most important thing on either of these slides is this link for 211. And you can go to the website 211wny.org, or you can call 211. And they will help to link you up with resources, rental assistance if it's available. There is a program that Buffalo has recently started, and they're accepting applications, but they're not actually processing them yet, as far as I know. But that's going to be getting off the ground and getting moving very soon. So if you owe rent, you should call 211, and they can connect you with that program. It's called Stand Up Buffalo. They can provide up to $4,500 or 3 months of past due rental assistance to help get you on your feet and avoid eviction if possible. Then the next page, some contact information for our office, the Volunteer Lawyers Project. We run a housing helpline. We run a housing helpline that is you can call and get a legal question answered quickly, ideally. Neighborhood Legal Services, of course, along with the Volunteer Lawyers Project, can represent you if there's been an eviction action filed in court. And then there are some other things you can check out here. Okay, now that concludes our presentation. I think we'll move on to questions.
So one question has been posted in the chat for our panel. How can I validate my hardship if my employer can't provide or won't provide a letter stating that my hours have been reduced? Is legal support available for this? So I think this guest wanted to know, or is saying that the landlord is requesting a document stating that, she has a financial hardship and is not able to get one from her employer.
So I can answer that. First of all, if you want specific legal advice for your particular case, you can call Volunteer Lawyers Project or Neighborhood Legal Services to get the answer specific to your case, because we can't give you legal advice here. However, in general, I want to point out that the hardship declaration is it is something that you are going to truthfully complete. So you do not have to attach proof to it. You do not have to show your landlord proof in order to file it with the court or send it off to your landlord. You can complete it. And there is a presumption that you are experiencing the financial hardship as long as you complete that form, because it is under penalty of perjury. It's as if you are a witness in a courtroom and you're swearing that what you are saying is true. However, it is a presumption, meaning that the landlord has the opportunity to prove that you did not tell the truth. So the landlord would have to prove to the court that you did not experience a financial hardship. You don't necessarily need, I mean, obviously paperwork or pay stubs would be easy to show that if you had to prove that you are receiving or that you are experiencing a financial hardship, but you can also prove it in other ways. If you have a bank account that and a direct deposit, you might be able to show that the amounts are less than what they were before. If you, I mean, there's different ways. If you have any, I think you said the landlord won't, or the employer won't provide a letter. If you have your pay stubs, that would be proof. But again, I want to make it clear that you do not need to prove this going in. You do not need to, in order to complete the hardship declaration, you do not need to prove anything. You need to fill out the form. If you qualify, sign and date it and send it to your landlord. And if you have a court case, send it to the court as well. And then at the hearing, if the landlord challenges you on that and says that you did not have a financial hardship, they would have to bring proof to the court. And that's when you would also want some proof in case the landlord is bringing up something. You would want to show the judge that you're telling the truth. But again, you do not need that in order to file the hardship declaration. You can just file it based on what is in the hardship declaration, fill it out and send it. I hope that helps. But if you need more information, you can call either of our agencies.
Thanks, Christine. We have a couple of more questions coming in the chat. And so again, I'm going to read them in order that they're received. And for our other participants, whether you're watching live from Facebook or you're in the Zoom meeting with us, please, again, feel free to post your questions in the comment and chat session. So the next question is, are housing courts open?
Anybody else? No, I'll answer that too. So in general, so Buffalo City Court is hearing a limited number of cases, as well as some of the town and surrounding courts in Erie County. Not all of them are hearing cases right now, and they aren't hearing cases in general. So they're not hearing new cases that have been filed. Everything's on hold right now, but they are open in terms of that there are a limited number of cases that are being heard in housing court.
Thanks, Christine. And then a few more. Is there any protection for landlords when tenants do not do the work to look into these additional resources that you've provided today?
I could answer this one. So in terms of these laws, there isn't a specific procedure to address that. But as Christine noted earlier, and it's important to reiterate, any of these restrictions, just the practical restrictions of the courts not being open or only hearing a limited number of cases, they're slowing things down, but it doesn't change the fact that the rent is still owed. None of these laws that we have discussed, none of these restrictions say that rent doesn't have to be paid because of the coronavirus. They just say that tenants are protected from immediate eviction in order to protect the public health.
To add on to that as well, with new filings in Buffalo City Court and town courts, the tenant hardship declaration is being included. So tenants are generally provided with that information as well.
And I just want to add, both on the tenant side and the landlord side, the biggest thing to remember during this time with the moratoriums in place is that there needs to be communication. So there needs to be communication between the landlord and the tenant as much as possible, so that, because a lot of these cases can be resolved without court interference. So the court is kind of the last resort when it can't be worked out between the landlord and the tenant. So I would say on both sides, there really needs to be a communication. There shouldn't be assumptions made. You should actually talk to each other about what is going on, what the current situation is, and try and work it out because the moratorium is in place. And if you do work it out, you won't need to then go to court once they do open fully.
If I could add one more note to that, I saw a similar presentation to this that was given yesterday, And one thing that they emphasized there was that communication is very important between the landlord and the tenant. And to get that started, you have to set aside some of your assumptions. So the tenants should not assume that landlords are, rich and well off and they can just absorb the financial hit. You don't know what their situation is, and you won't know until you talk to them about it. And landlords shouldn't assume that a tenant has the money and is just choosing not to pay them, or they got, all kinds of extra unemployment assistance or pandemic unemployment assistance, or even these federal stimulus checks, because a lot of people didn't receive those or had trouble, accessing them. So there are a lot of assumptions that get made that prevent a dialogue. And if you can get past that and actually talk to your landlord or talk to your tenant, you might be able to work this out.
Thank you, Christine, Michael, and Chris for that response. It actually segues right into the next question that we have. If a tenant has not given any documentation and has not paid any rent, can the landlord begin proceedings?
So in general, there is a stay right now for 60 days of previously filed cases. So I would say you should ask your attorney or the court directly. It depends on what court you are in as well, whether they are hearing cases, but everything is delayed right now. That's the best answer. Is they're still going through cases that were pending back in March, April, May. So it is my understanding newly filed cases, whenever that can be possible, will take a while to go through the court system.
Okay, and we have two more questions that just came in. In regards to living conditions, is there any responsibility that the city or county has when there is a rodent problem in the neighborhood?
Mike, do you want to maybe take this since NLS handles warranty of habitability?
Could you please just repeat the question as well?
Yes, absolutely. In regards to living conditions, is there any responsibility that the city or county would have when there is a rodent problem in the neighborhood?
As to warrant of habitability issues, one thing that we do recommend is clients and tenants can call the city building inspector as well as the health inspector, which will bring someone out generally to take a look at the conditions that exist, make notes, and then they can potentially issue citations and compel landlords and others to make repairs regarding those issues.
Thank you, Michael. Another question in regards to eviction petitions, can they be filed if the rent is not, if it's not a rent related issue? So I guess this question is, you can still file eviction petitions even if there aren't rent related issues due to COVID during this time.
That would be essentially the same answer as what Christine said before. For a specific answer, you'd have to talk to an attorney and get specific legal advice about your situation. But notwithstanding the stay on evictions, the 60-day stay, yes.
Thank you, Chris. I know we're nearing the end of our presentation, so I just wanted to remind everyone as well that this is streaming live on the BPS Parent Center page, so you can always go back to review the live stream from the beginning. It will also be made available on the Say Yes Buffalo YouTube page, and we will be able to share this presentation out to those who are interested. So if you send an email to gsmallwood@sayyesbuffalo.org and request the PowerPoint presentation, we will be able to share that with you. So we have one additional question in the chat, and then the last thing that we'll do after we kick it back to our attorneys is remind everyone that VOP does have a hotline. So we know some of the questions are, a little personal and maybe to your specific circumstance, and we ask that you definitely use the hotline to address some of those questions as well. So our last question that popped up says, if a person is on a fixed income, could their wages be garnished if they are months behind on rent? Is that something that a landlord has the ability to do?
So if you want us to give you specific legal advice, you can contact us. But in general, there is a process before a landlord can get a money judgment against a tenant. A money judgment is something that's granted by a judge after an eviction proceeding. And if the judge determines that you do owe rent, the judge would grant the landlord possibly what's called a money judgment. And then the landlord would have to go through a process and procedure to try and collect on that money judgment. I'm not going to go into the ins and outs of what qualifies and what doesn't qualify for garnishment right now, because that's more of a personal question. So if you want to call the helpline, we can definitely give you more information and more directed personal information. But generally there is still a process. So the landlord would either have to do an eviction proceeding or take you to court specifically for the rent money that is owed regardless of the eviction, and a judge would have to grant a money judgment. So there is quite a extensive process before a landlord could try and do that.
Thank you, Christine. So I'll just ask our panel of attorneys, as well as our CS Legal Clinic coordinator, Emily, if they have any final comments to give to our participants who joined us in Zoom or Facebook Live. Again, as all of you can see, we have posted our free legal advice hotline flyer and the number directly to address any housing questions. And I'll read it out loud for those of you who may not be able to see it. It's 716-828-8460. Again, if you have housing questions, please call 716-828-8460. A huge thank you to our team, and I'll turn it over to Emily and the attorney.
Thank you again, everyone in the community that signed in to today's presentation, our Know Your Rights session. I know housing is a very hot topic, especially since COVID-19, that a lot of people have had questions on and are currently living through some situations regarding housing. So we appreciate everyone attending, and I hope this was helpful for everyone. Again, these will be available on the Say Yes Buffalo platforms on Facebook and YouTube. So please feel free to rewatch it if you have any other questions. Our contact information is showing right now on the slide. So please, if you have any legal issues that you're going through, don't hesitate to reach out for help. If we can't help you, we will definitely kind of refer you in the right direction. Thank you again to Christine, Chris, and Mike for your hard work on this presentation. I know myself and everyone attending really appreciate all of this information. If you want copies again of the PowerPoint, please reach out to Jelena. We should have that available for any attendees that are interested.
Thank you, Emily, and I'll share that email again, gsmallwood@sayyesbuffalo.org. And again, if you have housing related questions, please contact the VOP hotline at 716-828-8460. Thank you everyone for joining us, and have a great day.
Thank you.